Man, I didn't think I had it, honey. I didn't think I had it in me, baby. I don't know what the hell done got into me. You see what happens when you pull out of political talk and you get all your damn life force back, okay? Because now I'm back, baby, working full time, girl. As long as I was internalizing all of this ish happening politically, I was not going to be able to get my mojo situated, child. The best thing I could have did for my mental health and my emotional well-being is to really just take my head out of what's going on politically, more so kind of trust in the process and just really strategically, you know, pay attention, but definitely can't be doing no daily doses of the political spirit. I can't do it, baby. Can't do it, baby. So now I done got all my synergy, all my infinity stones are galvanizing. Y'all already know what we're here to talk about. Hopefully we ain't going to be here for a billion years either, but I got to come back and talk about this. We got a major courtroom update in the TD Jakes defamation lawsuit against accuser Duane Youngblood. Before we get into it, go ahead and run me all those likes. You guys thought I thumbed up the video. Not only helps with YouTube's algorithm, but more importantly, it triggers up YouTube's notification system. So when you are thumbing up the video, you are literally knocking on the digital door of another Conscious crew member and telling them to get their black asses into the sanctuary. So please run me all those likes because I'm working bike to bike. You know, my notification cycle has not cycled. So our only hopes is you running those likes up. All right. If you can use those fingers, just type it to the chat. You can use those fingers to click on the link. You can definitely use those fingers to give me a nasty thumbs up for free 99. Speaking of thumbing up and free 99, if you guys appreciate the King's work ethic, you can always donate to the platform at $Consciouztv on Cash App and or PayPal.me/Consciouztv. Consciouztv spelled just how it is here on the platform. Make sure that you guys have all of your notification bells set to all. And last but not least, please share the stream to wherever it is you have digital community, whether that be your YouTube community wall, your Snapchat, your MySpace, the dark side of Twitter, Tumblr, or your personal OF. I don't really give a damn where you in fact lay the line. Just let them whores know that we're loud, we're live, and we're certainly in color. And with no further ado, let's go ahead and push on through.
I know a place where you can recharge your soul.
Baby, that's Consciouztv.
And in the midst of brokenness, he gon' see your asshole.
Baby, that's Consciouztv.
You gon' heal, you gon' laugh and catch a little shade.
Ooh, girl.
Y'all know he be slaying, y'all better stop playing. Come hear what he's saying.
Ladies and gentlemen.
What's going on, Consciouztv? Can y'all hear me? Give me a 1 in the chat. Something just happened with my audio. I don't know what the hell just happened with my audio. Give me a 1 in the chat if y'all can hear me. Before we go any further. Okay, we got ones. All right, great. Shout out to my baby mother Ashley for the nasty piece of shout support chef for the tea just brewing and you working. CTV is full time in the kitchen at this point, baby mother. The king is full time in the damn kitchen. The news just won't stop newsing, not even a little bit. This is insane. Let me go ahead and speak to the country crew in the building. What's going on, Sam? What done happened? Not every damn thing done happened. Y'all see how much shit happens in just 30 seconds now? We living in an expeditiously futuristic ass system now, child. Okay, one day is literally half a day now. What's going on, Lady D? Hey, Britt. What's going on, Trevor? Hey, Ian Gardner. Hey, Ashley. What's going on, Danielle, what's going on, Katie? Yes, baby, we're working, child. Hey, Chef, what's going on? Yes, I do have the legal documents. I went into Pacer and saw the update. So yes, honey, shout out to Chef, who also is, well, I don't know if Chef want me to give away, you know, the identity. I'm gonna email you back too, Chef. Shout out to my baby mother Teresa for the nasty piece. Child support for part 2 of the tea. That part. That part. What's going on, Shayla? Hey, Karen. Yes, we are. Hey, Just Be Real. Hey, Boo. Hey, Carolyn. Hey, Yvette. What's going on, Just Landis? What's going on, Lumen? Hey, stranger. Act like you can't text nobody. Hey, True Teller. What's going on, Crystal? Hey, Brett. Hey, y'all. What's going on, Joshua? Hey, Boo. Hey, Peace 4 BJ. What's going on? You can't just... Okay, y'all. Hold on. No, I'm going to give away Chef's identity in the next update because I'm going to try to have Chef up here with me. Okay, since Chef is an old nasty piece of content creator, child. Okay, he had done kept all that from me. I didn't even know Chef was a damn he. By God, what's going on? Hey, y'all. Hey, everybody. Okay, y'all. So we got to get into an update. Let me see how many pages we got up her. Let me see how many damn pages we got up her for one. Let me see how much of a read this is going to be, child. We've just been reading legal docs all damn day long, honey. I definitely had to be a attorney, a judge, or old nasty piece of paralegal back in the day. My God, let me see. How many pages? Okay, this is it's a 40-page. Well, it's a 18 page document. Okay. All right. So where do I sound off? All right. First and foremost, you guys know TD Jakes sued the living dog shit out of accuser Duane Youngblood, who had did 2 different interviews with Larry Reid Live and practically accused TD Jakes of attempting to sexually groom him when he was a young man. I think he was 20, 21 years old, between 19 and 21. And apparently TD Jakes was a guest speaker at his church, etc. And TD Jakes on one occasion attempted to lean down and kiss him unsuccessfully while he was walking Duane Youngblood to the door following an intimate conversation around Duane's upbringing and, you know, with his dad and being fatherless and all of this and all of that. And then Duane claims the next day, TD Jakes called his mother's home and asked to speak to him, where TD Jakes basically propositioned him sexually to be one of his whores and chamberlain maids in the harem, and told Duane that pretty much he would be taken care of for the rest of his life. Apparently, Duane felt completely appalled and disrespected by this. It led to Duane going to the administrative office of the church that him and Jakes was, well, he was a member at the church. TD Jakes was a affiliate to the church. And apparently there were these administrative confrontations that took place regarding what TD Jakes had allegedly attempted to do to Duane Youngblood. That pretty much nothing came of it, apparently, and that was that. All right. Now, TD Jakes also, in his defamation suit, of course, denying all allegations, claiming that this is not true. It did not have been exposed the fact that Duane Youngblood is a lying-ass motherfucker. And come to find out, Duane Youngblood is a whole registered ex-offender. And I'm talking about like the worst type of ex-offenders. You know, it seems to be levels to this shit. You know, there's like level 1 sex offender, and then there's like just the beyond of the beyond girl, okay? Essentially, Duane Youngblood had been locked up, penalized, and utterly sentenced for doing the very same thing that he was alleging TD Jakes did to him, but worse. He caught what TD Jakes tried to do in an attempt, but Duane Youngblood also represented himself as a pastor, and he lured underage young men into his church under the guise of helping them overcome their sexual childhood trauma, but instead took advantage of them, and sometimes right in the damn church house. Okay? He was tried and sentenced on multiple convictions dealing with multiple underage boys. He was sentenced. He got out. He got on probation. He ended up going back to prison for violating probation because he continued to make contact with underage young men, which was a part of his probation stipulation. And his SA stipulation is that he had to stay away from underage people. Okay? Now, Duane Youngblood attempted to defend himself in this litigation, claiming that this isn't the first time he spoke out against TD Jakes. He's been speaking out over the course of the last, 2 decades against TD Jakes, that this lawsuit is completely frivolous, and this is TD Jakes attempting to suppress his First Amendment rights and his freedom of speech, and that his speech alone doesn't constitute defamation because he is not intending to be slanderous or malicious, which is a principle of defamation. He is simply telling his lived experience because it is, in fact, his lived experience. All right? As he began litigation, he also initially started off representing himself pro se. Tyrone Blackburn, snake ass, who is the equivalent of Tony Busby as a lawyer, entered the group chat and represented him and claimed that there were multiple accusers, okay, against TD Jakes, not just Duane Youngblood. Now, further context here. In the earlier stages of this lawsuit, there was all this aforementioned about this being a bad idea. According to Larry Reid Live, he thought that TD Jakes was putting his big foot in his own mouth by suing Duane Youngblood. He stated that there were going to be multiple accusers who were going to roll out their accusations against TD Jakes, etc., and that pretty much just more than likely would be the beginning of the damn end when it comes to TD Jakes. Well, Youngblood followed behind that in his suit, or in his defense of himself in his defamation suit, by claiming that he had a lot of accusers who were ready to come forward against TD Jakes. They were all lined up. They were ready to sign sworn affidavits. They were all willing to be witnesses in this trial and suit, etc. And of course, that was said prior to him presenting any evidence to corroborate that. So I took it as an intimidation factor on Duane Youngblood's part. He was attempting to legally intimidate T.D. Jakes and back him down under the false guise that there were going to be all these accusers and all of these people and men who had been violated by T.D. Jakes. Duane claimed he had spent lots of time on the phone conversing with these men about their stories, and that their stories against T.D. Jakes were far worse than his own. Only for Duane Youngblood to turn around in the next filing, present maybe 10 affidavits, and only one of those affidavits were from someone who had alleged that T.D. Jakes also had tried them back in the late 90s and 80s, which happened to be Duane Youngblood's own brother, Richard Youngblood. Richard Youngblood claimed that sometime back in the early 90s, late 80s, I believe, that he assisted T.D. Jakes as a personal driver and pretty much as a PA, and that during one of their commutes where he was transporting T.D. Jakes to another church outside the city, that they decided to get a room in order to, rest up for the remainder of the road trip. During this time, Richard Youngblood went to bed alone, but woke up with T.D. Jakes' big ass in his bed right beside him, almost like spooning him from the bike, and that he could feel T.D. Jakes' large kojic penis just lodged in the crack of his ass. So he jumps up and has a adverse reaction to this. Like, what the hell is going on? What is this? He claims T.D. Jakes gets up off the bed, walks around, put his hands on Richard's shoulders, attempts to calm him down, etc. But despite the situation, Richard decided to calm down, despite being afraid to go back to bed, and continued to sleep in the same room with T.D. Jakes until the following morning. He said by the morning, they got back in the car, commenced to the commute. He confronted T.D. Jakes about the situation. T.D. Jakes pretty much gave him some flimsy excuse. And then eventually he reported the incident as well to another church administrative personnel person, which then, according to Richard, led to T.D. Jakes calling him into his office and pretty much berating him, chastising him, and kicking him out of the church and attempting to weaponize his wife against him, etc. And he sworn that these events were true. Now, shit got fucking crazy when T.D. Jakes had to respond to Richard Youngblood. And me and my co-host at the time, Will, who is the alleged ex-sneaky link of Youngblood. I believe he met Youngblood back in either the mid or late 90s under the guise that that Duane Youngblood was single. He was pretty much, a sugar baby for Duane, allegedly. But he broke off the relationship when Duane Youngblood allegedly wanted Will to ride his dick in the church's office where all of Duane's family portraits were of his children and wife. Which was the first time that Will had learned that Duane was even a married man. He claimed that Duane Youngblood attempted to slander him by contacting his aunt and accusing Will of giving him STIs and STDs, which was not true, according to Will Gworlll. It was a whole hot goddamn mess. And Will practically wants to see TD Jakes get the ultimate lit back on Duane because he pretty much thinks of Duane Youngblood as a piece of shit. All right? Now, the gag was when TD Jakes responded to Duane and all of these affidavits submitted, might I add, the other affidavits that Duane submitted were not from victims or accusers, but just from people who had alleged that Youngblood had confided in them about this incident over years, because Duane was trying to prove that, oh, this ain't the first time I spoke out against him. I've been sharing this. I've been stating this, blah, 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 blah. So after I did my last review, I was like, well, where the hell were all these accusers? Apparently, there's supposed to be a family that was going to come forward because TD Jakes had allegedly violated one of their underage children, and there was going to be affidavits from these people, and there was all these ex-boyfriends from TD Jakes, and they were just blah 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 blah. The only accuser that submitted a affidavit was Richard Youngblood. Where the gag was, y'all, when TD Jakes responded back, they exposed the fuck out of Richard Youngblood. They exposed the fuck out of all these other people who had submitted sworn affidavits. TD Jakes let it be known that, first and foremost, this incident never happened. For the commute from where they were in the city to the church outside the city didn't even require no overnight stay anywhere, for one. Okay, it was a straight through drive. And for two, Richard Youngblood just attempted to work for the Potter's house like just a few years ago. So you claiming that your brother telling the truth about me, that I tried to come on to him way back in the day and call his mama house, and then you try to accuse me of trying to hook up with you at a Red Roof Inn stay, but yet you tried to submit an application and be an employee and work for my church. Make it make sense, girl. My mouth was on the goddamn floor, y'all. On the floor. To make it even worse, y'all, do y'all know that some of the other sworn affidavits that Youngblood submitted from people that had claimed that Youngblood had confided in them were actually affidavits provided by other sex offenders? Y'all, when I tell y'all TD Jakes tore Youngblood and Tyrone Blackburn's assholes wide open, girl, that if he had not already violated their asses, he definitely did at that moment, baby. He tore Duane and Tyrone Blackburn a fucking new one. The way they ran down the fucking list and exposed all the people who submitted sworn affidavits and Richard Yup, baby, I was gagged to the ground, y'all. Y'all, I melted into the fucking floor. I lost it. I lost it, girl. I was completely and utterly shook. All right? I was like, there's no way that Duane Youngblood ass is going to be able to come back from this bitch. I'm like, there is nothing that this nigga can say to make it make sense. Y'all, I ain't never seen no comeback like that, girl. I thought that they was going to have TD Jakes' ass by the kahunas. I thought they had grabbed him by the balls. We was expecting all these accusers, girl, all these people to come forward, baby. Ain't nobody come forward but Todd ass Richard Youngblood, who claimed TD Jakes tried to come on to him, and he was grown at the time as well. So it really was completely irrelevant, to be quite honest. But also forfeited in his affidavit, telling us that he was just trying to seek employment from the same man that is being accused of trying to actually groom his own brother and who tried to violate and come on to his ass as an apprentice. And then expose all the other affidavit providers and they mug shots, they sentences, they crimes against children, bitch. It was diabolical, girl. It was a diabolical run through, girl. TD Jakes became that girl. He scored a good solid 10 3-pointers, girl, in just that alone. So it was evident to me that Tyrone Blackburn nor Duane Youngblood had thought this shit through, baby. I don't know why they thought that TD Jakes' attorneys were not going to do the homework, who were not going to look into these people who were submitting these alleged affidavits, girl, because they fucked around and found out in the worst way. All right? So the next thing that had happened on the docket was Duane had submitted an anti-SLAPP motion. Okay? Now, Larry had came onto my platform last year and pretty much said that he suggested that Duane Youngblood do an anti-SLAPP, etc. He himself don't went to school for political science, etc., girl. And that, he believed that the anti-SLAPP would get Duane Youngblood off. For those of you who don't know what the hell anti-SLAPP is, anti-SLAPP is short for strategic lawsuits against public participation. SLAPPs have become an all too common tool for intimidating and silencing criticism through expensive, baseless legal proceedings. Anti-SLAPP laws are meant to provide a remedy to SLAPP suits, okay? So basically, this is an anti-SLAPP is for smaller entities who are being snuffed out and pretty much being dragged through the legal system unjustly by a larger entity through the means of that larger entity's money, who's able to really hold a person hostage in the legal system, make them spend all their goddamn money fighting what is in fact a frivolous lawsuit to begin with, and running smaller entities practically bankrupt. So the courts have intervened by providing a way out and to keep larger corporations and entities from using their money, essentially weaponizing their coin, because they can go the long haul in litigation versus, a smaller business versus, an ordinary civilian, etc. So Larry had recommended the anti-SLAPP. Well, the anti-SLAPP was goddamn dismissed, bitch. I guess Larry Reid gonna have to go back to school, baby, and complete them goddamn political major ass courses, girl. Because TD Jakes scored a major victory today in court and had the judge deny the anti-SLAPP proposed by Duane Youngblood and his team. The judge presiding over the case wrote a memorandum opinion, which we're going to read today, girl. This is what the judge had to say. Now, mind you, we ain't seen no action regarding the suit in a minute, child, okay? It's been a good month and a half, 2 months, okay? So the court's done dealt and sorted through everything. This is the memorandum opinion of William Stickman, the United States District Judge. Plaintiff Thomas Dexter Jakes brought this action against defendant Duane Youngblood and 10 unidentified individuals. At count 1 brought against Youngblood, Jakes alleges that Youngblood engaged in libel per se. Hey, everybody. Hey, y'all. Hey, everybody coming to the chat. Y'all give me a thumbs up. I need all the likes. At count 2 brought against all defendants, Jakes alleges that defendants engaged in a civil conspiracy to commit defamatory acts. Youngblood filed a special motion to dismiss pursuant to Pennsylvania's anti-SLAPP statute. For the reasons articulated below, the court will deny Youngblood's motion. Bitch, somebody tell Duane Youngblood to run, ho. Because, baby, I told Youngblood to run after TD Jakes had to expose him and all his cohorts, girl. In them damn affidavits, bitch. Run, girl. All right? For these reasons, the judge denies Youngblood's motion. Factual and procedural background. On October 28th of last year, Youngblood was interviewed on the Larry Reid Live online video podcast. The episode was allegedly titled "The Abused Become the Abuser." During the interview, Youngblood alleges that Jakes groomed and actually abused him when he was 18 to 19 years of age. Specifically, Youngblood alleged that Jakes attempted to kiss him and subsequently caught him on the phone and made statements regarding future actual encounters between Jakes and Youngblood. Youngblood stated that the encounter between himself and Jakes was absolute destructive actual damage. Youngblood described another conversation that took place with Jakes years later, where Jakes allegedly stated that, quote, "My stock was rising. I would have had sex with anybody at that time," in reference to the prior alleged interactions between Jakes and Youngblood. On November 3rd of 2024, a second part of the LRL episode aired. In that episode, Youngblood repeated his previous allegations toward Jakes. Jakes subsequently brought this lawsuit under the court's diversity jurisdiction against Youngblood, alleging that Youngblood's allegations are patently false and defamatory. At count 1, Jakes alleges that Youngblood's statements on the October 28th and November 3rd episodes of LRL are libelous per se, in that they expose Jake to contempt, ridicule, and whatever the fuck that word is, which tend to affect Jakes in his profession as a trusted pastor and religious figure, and accuse Jakes of engaging in unlawful conduct. At count 2, Jakes alleges that Youngblood, along with 10 unidentified defendants, acted in concert to publish and broadcast a false claim that Jakes groomed and actually assaulted Youngblood on a podcast reaching over 100K persons, knowing that making such false claims on a podcast that reaches such a broad audience of listeners would harm Jakes. Youngblood filed a special motion to dismiss pursuant to Pennsylvania's anti-SLAPP statute, arguing that 1, Youngblood's statements are protected public expression, 2, Jakes cannot establish a prima facie case of defamation or civil conspiracy, and 3, public policy and Pennsylvania's anti-SLAPP statute support dismissal of Jakes' complaint, and 4, Youngblood is entitled to attorney fees. Youngblood also requests leave to file a cross complaint against Jakes and his son Jermaine Jakes in relation to a message Jermaine Jakes sent Youngblood via social media. This is the judge's analyst. The court will deny Youngblood's motion brought under the Pennsylvania's Uniform Public Expression Protection Act. Youngblood filed a special motion to dismiss pursuant to Pennsylvania's anti-SLAPP statute. Youngblood did not mention Federal Rule of Civil Procedure 12B6, Rule 12B6, nor did he address Rule 12B6 legal standards. Instead, Youngblood focuses exclusively on the Uniform Public Expression Protection Act. The Uniform Public Expression Protection Act is often referred to as an anti-SLAPP statute, although SLAPP, an acronym for Strategic Lawsuit Against Public Participation, does not appear in the Act's title. The Uniform Public Expression Protection Act is considered an anti-SLAPP act. SLAPP lawsuits are generally meritless suits brought by large private interests or to deter common citizens from exercising their political or legal rights or to punish them for doing so. Of particular importance to Youngblood's motion is some statutes all up in there. The court will address the application of each subsection in turn. For the reasons articulated below, the courts hold that 1, statute is not effective, 2, statute is not applicable in federal court, and 3, statute is not relevant at this stage of litigation. Youngblood purports to rely on 42 statute 42 Pennsylvania statute as the mechanism permitting him to file his special motion to dismiss pursuant to Pennsylvania's anti-SLAPP statute. The court holds that statute has not yet taken effect. Under this said here statute, quote, a party may file a special motion for dismissal of or judgment on a cause of action or a part of a cause of action based on a party's protected public expression immunity. In ruling on the special motion to dismiss, the statute directs the court to consider the special motion to dismiss responses and the evidence which can be considered on a motion for summary judgment. The act establishes a procedure that shares many attributes with summary judgment. So, consistent with summary judgment practice, parties should submit admissible, competent evidence such as affidavits, depositions, testimonies, or tangible evidence for the court to consider. Nevertheless, statute that there right there is only effective if any of the following actually occur. 1, a promulgation by the Supreme Court of Pennsylvania of a rule similar in from all of that legal shit there, stating that the provisions of all of those statutes there are not suspended. 2, promulgation by the Supreme Court of Pennsylvania of a direct letter of address similar in form to all them statutes there, stating that the provisions of those statutes there are not suspended and do not violate Article, whatever the fuck that is, of the Constitution. Is that, is V? What is V in Roman numeral? Hold on, let me look that up, child. V Roman Dungeon Dragon. Rah. Okay, yeah, 5. I ain't been out of school that goddamn long. Actually, I have. Of the Constitution of Pennsylvania, and 3, promulgation by the Supreme Court of Pennsylvania of procedural rules providing substantially the same content as the provisions of 42 statutes, all up in there. The Supreme Court of Pennsylvania has not promulgated any rules or issued a direct letter of address regarding that statute or any similar provision. Thus, statute is not effective and has no bearing on this litigation. It is not an operative law. Youngblood purports to file his special motion to dismiss pursuant statute mechanisms. His motion must fail on procedural grounds as the subsection under which it was brought is ineffectual, since statute is not good law. Youngblood's motion may not proceed under the... And see, this is why I said everything I motherfucking said about Tyrone Blackburn. I do not feel sorry for Youngblood's grapey, sex-offending, ratchet, raggedy, broke, pro se representing ass. Because you actually allowed Tyrone Blackburn to represent you, baby. All you would have had to do was just do one Google search, baby, and you would have saw that your case was going to collapse just from having his ass on board all by itself. Considering how weak these goddamn allegations against TD Jakes already are, girl. So your allegations were already thin as hell. And then you brought on the black version of Tony Busby to the goddamn case. And this just goes to show how incompetent and sorry Tyrone Blackburn is. And I'm going to say it all the time, every motherfucking day. Okay? Just more sheer embarrassment on Tyrone Blackburn's side, bitch. I know people personally who have been represented by Tyrone Blackburn, girl. We ain't even talking about the celebrity cases. Who this nigga's incompetency, his immaturity, his lack thereof, costed them their case, stalled their motherfucking case. How I got this blue shit on here? Hold on, y'all. Let me get this blue highlight off this page. How I did this? Okay, fuck it. We just gonna be blue. So, I mean, what the hell was Duane Youngblood? You know, I guess the gag was okay. So here, I forgot. We got a lot of other elements, y'all. Remember, Duane Youngblood and Tyrone Blackburn didn't think the shit was gonna go this far to begin with. Remember, because they sent a demand letter prior to Jake suing the fuck out of Duane Youngblood, demanding $6 million out of TD Jakes in order for Youngblood to be quiet. And like I said in the beginning, why in the fuck would TD Jakes pay you $6 million to shut the fuck up when you've already done the damage through the LRL platform? You've already done the damage in 2 different fucking interviews. So what the hell is you being quiet now? Supposed to serve him, girl. When the interview done went viral, it's all over TikTok, it's all over these social media platforms. So, yes, that should result only in TD Jakes just go ahead and suing the fuck out of you to really stop your motherfucking ass from grifting off his name. So I don't believe that it was ever supposed to go this far to begin with, especially when Youngblood was initially representing himself pro se. Once TD Jakes continued to stand on Youngblood's motherfucking neck, then Youngblood had to really go to get the scrambling, especially as the courts established that there was some merit on TD Jakes and TD Jakes' lawsuit, girl. So then Tyrone Blackburn must have thought, okay, cool. The court's gonna green light this shit. They gonna let him take you to task. I'll come in more than likely and represent you pro bono. And then you just give me an established cut, because I'm sure at some point we're going to get to a mediation. Jake's going to fold because he can't deal with the smoke. He can't deal with the fire. He's not going to want this negative publicity. So we probably won't even have to go to trial. We'll throw some, a nice sum settlement numbers out there. Everything will be cool and this will all go away. None of this is turning out the way that Tyrone Blackburn thought it would. None of this is going the way that Duane Youngblood thought it would. And none of this damn sure is going the way that Larry Reid assumed that it would go after he was the one who encouraged Youngblood, courtesy of his own political science degree, to utilize the anti-SLAPP, which is now being formally dismissed because it fails procedural grounds. Youngblood bets to fucking run. And speaking of Larry Reid, Jake's tried to get the courts to greenlight a very early discovery against Larry Reid because Jakes is suspecting that he is one of the 10 John Does and co-conspirators that is co-angling this destructive smear campaign against him. The courts denied TD Jakes because they practically said it's too early on for us to be green-lighting a discovery. But when that time comes, we may revisit. We can revisit, discovery upon Larry Reid. So Larry also is not out of the woodworks either. Okay? TD Jakes has already asserted in previous filings that he's definitely coming for Larry's head top as well, and that he plans on getting all up in the middle and inside of this shit, which I have another hypothesis. Someone recently sent me a post of Larry, apparently, I guess, asking any public figure that has a problem with any commentary that's out about them to email him directly, and he's willing to remove that said content because he's rebranding, etc. Girl. Well, people were speculating what the hell was contributing to this. I think what's happening is that Tyrone Blackburn probably communicated at some point that with the courts taking so long Tyrone Blackburn more than likely communicated to Larry, who Tyrone Blackburn has been on Larry's platform talking about this lawsuit, etc. Probably told Larry, look, the courts are probably about to green light Jake's shit because it typically don't take them this goddamn long to honor an anti-SLAPP if that's what they're going to do. The fact that it's been months now since the courts have said anything, since we've submitted our anti-SLAPP, we need to get ready for them niggas to honor Jake's and deny the anti-SLAPP. Larry, in return, may have got shook because Jake's already done established, I'm coming for you, nigga. And just because I didn't get this early discovery approved, trust and believe, when it gets time for discovery, I'm coming. I'm coming for emails. I'm coming for affidavits. I will subpoena Google, AT&T, whoever your phone provider is. I will subpoena it all because I know TD Jakes is convinced. He's like, nigga, I know you had something to do with this and you're not just little Mr. Innocent. So Larry, trying to be a clever Aquarius, may have tried to really secure his immunity without trying to be obvious by putting out a post really meant for TD Jakes and his team. For anybody out there who has an issue, anybody else, now mind you, it ain't really no, concerning content about really anybody else on Larry's platform aside from TD Jakes, really. The TD Jakes shit was the most explosive shit to come out of Larry's content over the past year or two or so. So, Larry trying to be inconspicuous with debating anybody, hey, I'm rebranding. Hey, if anybody feels a way, anybody has a problem with any content on my platform, any content that you don't like, any content at all, email me at larry@gmail.com. Might want to do that. More than willing, honey, more than willing to delete some shit, more than willing to rectify the situation, more than willing. Now, considering that the courts done denied the fuck out of Youngblood and those interviews are still up, I'm going to surmise that TD Jakes ain't sent a motherfucking email or sent none of his minions or sent a, as Larry would call it, a TD Jakes fixer to communicate at motherfucking all because TD Jakes wants the smoke. TD Jakes wants motherfucking blood out of these niggas. TD Jakes is in his Jay-Z bag against Tony Busby and Jane Doe, baby. He want the smoke. And TD Jakes has been consistent in holding these niggas accountable because he also last year took up legal issue with Google and subpoenaed them to provide them with information about YouTube channels that have been pushing slanderous AI content against him because, baby, TD Jakes is about to wreck motherfucking shop, bitch. So that's my hypothesis for why Larry potentially made that goddamn post, baby. And, baby, he got good damn sense to be doing so. Because just like I'm telling Duane ass to run, bitch, Larry best to put on his best kitten heels and get the skedaddling as well, baby. Because Jake's ass is on girl. He done had, he said them niggas done gave his ass cardiac arrest. They almost took his ass out and he ain't going out by his damn self, baby. Okay? He gonna give these niggas the 1-2 they been begging for. Okay, TD Jakes said, nah, nigga, I done seen what y'all tried to do by using Manasseh, what your ass tried to do using the goddamn Duane. It's been one thing after the other. Y'all want the smoke? Come here for the fire. Okay? So that's what I think is going the hell on there. The lawsuit goes on to say, grant of immunity. Youngblood alleges that he is entitled to immunity and judgment as a matter of law. Under 42 Pennsylvania statute, because his statements are supported by affidavits, which were exposed like a motherfucker, public reports, and corroborating testimony, and Jakes has not demonstrated actual malice or falsity. Youngblood repeatedly states that Jakes has failed to provide credible evidence to meet the burdens of said statute. Youngblood filed a multitude of exhibits with the court that allegedly supported the truthfulness of his statements. Jake counters that statute does not apply in federal court because it conflicts with the federal rules of procedure. God damn. See, this is what good quality lawyering does. Thus, the first issue before the court is whether a federal court exercising diversity jurisdiction may apply said statute. Even assuming that said statute could apply independently of said statute, the court holds that statute does not apply in federal court. Womp, wompity, motherfucking womp. The court acknowledges that there is a disagreement amongst courts as to whether a federal court exercising diversity jurisdiction can apply a state's anti-SLAPP law. While other state laws are not identical to said statute, these cases provide persuasive guidance to the courts, which are all these case laws here. Okay? In Abbas, the United States Court of Appeals for the District Court of Columbia Circuit that held, quote, a federal court exercising diversity jurisdiction must apply Rules 12 and 56 instead of the D.C. Anti-SLAPP Act special motion to dismiss provision. The D.C. Circuit determined that the D.C. Anti-SLAPP Act conflicts with the federal rules by setting up an additional hurdle a plaintiff must jump over to get to trial, such as all this case law up in here, for example. The court finds Abbas' reasoning persuasive, as in section, there you have it, and other anti-SLAPP statutes with similar provisions is a procedural rule, not a substantive law. It creates a mechanism for a defendant to resolve a case pretrial, much like federal rules of civil procedure 12 and 56. Pursuant to the Reid doctrine, a federal court sitting in diversity, I got hiccups, y'all, forgive me, must apply state substantive law and federal procedure law, such as case law there. This substantive procedure dichotomy of the Reid rule must be applied with the objective that in all cases where a federal court is exercising jurisdiction solely because of the diversity of citizenship of the parties, the outcome of the litigation in the federal court will be substantially the same so far as legal rules determine the outcome of a litigation as it would be if tried in a state court. The outcome determinative test, however, should not produce a decision favoring application of the state rule unless it furthers one of Reid's twin aims: discouragement of forum shopping and avoidance of inequitable administration of the laws. Consistent with these aims, the court must apply a three-part test to decide whether a state law or rule is substantive or procedural for Reid purposes. See case law there. First, the court considers whether there is a direct collision between a federal rule and the state law or rule that the court is being urged to apply. If there is a direct conflict and the federal rule is constitutional and within the scope of the rules enabling act, the court must apply the federal rule and end the analyst. In other words, a federal court exercising diversity jurisdiction should not apply a state law or rule if, one, a federal rule of civil procedure answers the same question as the law, or rule, two, the federal rule does not violate the rules enabling act, such as in case law there. The court holds that there is a direct conflict between statute and rules 12b6 and 56. But the category of cases that it covers, statute essentially supplants the Rule 12b6 motion to dismiss standard with the Rule 56 summary judgment standard. Now, for all of you who need a legal, break the fuck down, baby, of all these goddamn statutes and all that, girl, y'all head over to my boo, Pam the Law Esquire platform, girl. I think she also did a live stream earlier. Pam, I saw you called me the other day. I'm gonna return your phone call this week. As you see, girl, I've been swamped out here. Trying to have a damn personal life and trying to be, in my full-time commentary bag. But I got some time today or tomorrow, Pam. So I'm gonna call you back, okay, before this weekend is out. Pick up your damn phone, okay? But head over to my boo Pam, the Law Esquire platform, girl, if y'all need, the nuance of these goddamn statutes. But it's basically what's going on. It's the federal court kind of is undecided in this middle ground as it relates to certain statutes, and there are certain things that work for the states that don't apply federally, and it's kind of subjective in terms of how each court will deal with said anti-SLAPPing statutes. This particular court is not choosing to deal with it for the reasons that they are citing here. So this is resulting in a denial of Duane Youngblood's anti-SLAPP. But we'll continue to read. Rules 12B6 and 56 help form an integrated program for determining whether to grant pretrial judgment in cases in federal court, such as in case law here. Under Rule 12B6, a plaintiff can overcome a motion to dismiss by alleging facts sufficient to state a claim that is plausible on its face, such as case law there. A well-pleaded complaint may proceed even if it strikes a savvy judge that actual proof of the facts alleged is improbable. The court must accept all well-pleaded factual allegations as true and view them in the light of most favorable to a plaintiff, such as in case law there. Further, at the motion to dismiss stage, the court may not consider matters extraneous to the pleadings unless the documents were integral to or explicitly relied upon in the complaint, such as case law there. If the complaint survives a motion to dismiss, a party may move after discovery but before trial for summary judgment under Rule 56. Summary judgment is appropriate if the pleadings, depositions, answers to interrogatories, and admissions to file together with the affidavits, if any, show that there is no genuine issue as to any material fact and that the moving party is entitled to judgment as a matter of law. A factual dispute is genuine only if there is a sufficient evidentiary basis on which a responsible fact finder could find for the non-moving party, and it is material only if it has the ability to affect the outcome of the suit governing law, such as in case law there. In considering a motion for the summary judgment, a district court may not make credibility determinations or engage in any weighing of the evidence. Instead, the non-moving party's evidence is to be believed. All justifiable interferences are to be drawn in his favor, as in case law there. If a party fails to make a showing sufficient to establish the existence of an element essential to the party's case, on which the party will bear the burden of proof at trial, Rule 56 mandates the entry of summary judgment, as in case law there. A complete failure of proof concerning an essential element of the non-moving party's case necessarily renders all other facts immaterial. A person is immune from civil liability for a cause of action based on protected public expression if any of the following paragraphs apply. 1. The party asserting a cause of action based on protected public expression fails to 1. Establish a prima facie case as to each essential element of the cause of action, or 2. State a cause of action upon which relief can be granted. There is no genuine issue as to any material fact, and the person against whom the cause of action based on protected public expression has been asserted is entitled to judgment as a matter of law in a whole or in part. This section permits the courts to consider whether there are genuine issues of material fact, and seemingly requires the courts to look outside the pleadings to other evidence and documents submitted by the parties. It imposes evidentiary weighing requirements not found in the federal rules and operates largely without decisional discovery. Thus, there is a direct conflict between statute here and Rules 12 and 56. The Uniform Law comment to 42 PA statute acknowledges that the state operates in a procedural manner specifically by altering the typical procedure parties follow at the outset of litigation. Nevertheless, the commentary argues that the rights the Act protects are most certainly substantive in nature. The court does not believe that a procedural rule protecting a substantive right is, by the virtue of the right it is protecting, transformed into a substantive law. The statute exists to spare those who exercise their free speech rights from unwarranted and harassing litigation. However, statute pursues this policy goal through procedural means, such as in case law there. The substantive free speech rights underlined in the statute exist entirely independent of said statute. Section 834.0.15 merely provides a procedural mechanism for a speedy dismissal of a meritless lawsuit. In sum, Rules 12 and 56 answer the same question as said statute. Rules 12 and 56 therefore govern in diversity cases in federal courts unless they violate the Rules Enabling Act. The court holds that Rule 12 and 56 do not violate the Rules Enabling Act. The Rules Enabling Act empowers the Supreme Court of the United States to prescribe general rules of practice and procedure and rules of evidence for cases in the lower federal courts. A federal rule of civil procedure violates the Rules Enabling Act if it abridges, enlarges, or modifies any substantive right. So far, the Supreme Court has rejected every challenge to the federal rules that it has considered under the Rules Enabling Act. In determining whether a federal rule violates the Rules Enabling Act, the United States Courts of Appeal for the Third Circuit has stated this statement here, and here, and here. Okay, so it's just continuing to go through, girl, the breakdown of the breakdown of the breakdown. Okay, so here's some meat. In accordance with the Erie Doctrine and Shady Grove, the court holds 1, there is a direct conflict between said statute and Rules 12 and 56. And 2, Rules 12 and 56 are constitutional and within the scope of the Rules Enabling Act. The court must apply Rules 12 and 56. The procedural mechanisms established by statute cannot apply in federal court. Since the court cannot apply said statute, the court will not consider Youngblood's arguments brought under that statute. Youngblood seeks attorney fees pursuant to said statute. 42 PA statute awards attorney fees, court costs, and expense of litigation to defendants who engage in protected public expression if the court finds the defendant is immune under said statute or the opposing party voluntarily discontinues the action. Okay, so basically the court just said it's going to take either us to find the defendant being immune under said statute or TD Jakes voluntarily discontinuing this action. On the other hand, if the courts determine that a party assertion of protected public expression immunity is frivolous or filed solely with intent to delay the proceeding, the court shall award the opposing party attorney fees, court costs, and expenses of litigation incurred in opposing the assertion of protected public expression immunity, as noted in the prior sections of said statutes, respectively. 1, are not applicable in the federal court, and 2, not effective law. Consequently, the court will not make any findings with respect to whether Youngblood or Jakes is the prevailing party. The court holds that statute's award of fees is inapplicable at this stage of litigation, and at this time it will not reach the issue of whether statute is applicable in federal law. So Duane ain't getting a goddamn thing. He ain't getting nothing, baby. Okay, y'all thumbs up, run the thumbs up. There is no motion to dismiss pursuant to Rule 12b pending before the court. Youngblood's special motion to dismiss pursuant to Pennsylvania's anti-SLAPP statute is based entirely on the Uniform Public Expression Protection Act. In his motion and supporting brief, Youngblood does not mention Rule 12b-6, the governing rule at this stage of litigation. Moreover, Youngblood's motion is reliant on the summary judgment-like standard of said statute and other said statute. The court will not reframe Youngblood's motion as a Rule 12b motion. Youngblood relies on sworn affidavits to allegedly corroborate his statements and support his arguments. The court may not consider documents outside. God damn! What the fuck? Wow. under Rule 12B, subject to certain exceptions which are not applicable. Baby, no attorney fees, no motherfucking dismissals, hoe, and baby, they ain't even acknowledging nor dealing nor even allowing any further admissible conversation regarding those exposed as affidavits brought against Jakes on behalf of Tyrone Blackburn and Duane Youngblood. Bitch, I am fucking screaming. What's going on, Nav Squad? Hey, the Lee Williams Show. What's going on, Toko? I am screaming, y'all. The judge goes on to say, moreover, Youngblood's arguments are fundamentally incompatible with the Rule 12 BB standard. For example, Youngblood argues that Jakes has not presented admissible evidence to prove that Youngblood's statements were false and made with malice. Youngblood further contends that Jakes fails to establish by clear and convincing evidence that Youngblood acted with actual malice. Youngblood's motion, based on the Uniform Public Expression Protection, fundamentally diverges from Rule 12b6 standard. At the motion to dismiss stage, Jakes does not have a burden to present admissible evidence. Pop goes to goddamn whistle. And you know who's supposed to know that? You know who's supposed to be skilled and competent and effective? Tyrone Blackburn. Tyrone Blackburn threw some lazy shit up there, not giving a fuck, because he really just don't give a fuck about what happens to Duane Youngblood. He only, in my personal opinion, even offered to pro bono Duane Youngblood because he, like Tony Busby, was hoping on what they said in their demand letter to be a $6 million out-of-court settlement, which was alley-oop and reverse uno'd and resulted in Duane getting the shit sued out of his motherfucking ass. So in these half-ass attempts for Tyrone Blackburn to represent Duane Youngblood, Tyrone really ain't got no more use for Youngblood. That's why his lawyering is so lazy, which actually might be a true testament, girl, of just his capabilities as a lawyer as a whole, considering that the courts consider Tyrone Blackburn largely as a legal clown. But the fact that Tyrone Blackburn is just selling Duane Youngblood down the Nile River, girl, is crazy, girl. If Duane Youngblood got any goddamn sense, he would get rid of goddamn Tyrone Blackburn and get him a separate competent counsel, because for all we know, baby, Tyrone Blackburn getting the cut check. The check is getting cut, girl. Tyrone Blackburn working for the motherfucking ops, because who's supposed to know all this is Tyrone Blackburn. Who's supposed to know, girl, how he supposed to be arguing Rule 12b6 along with these other motherfucking statutes? It's supposed to be Mr. Blackburn. Tyrone Blackburn did such a sorry, pathetic, baseless attempt at this anti-SLAPP motion that the judge is practically saying, girl, you might as well just should not have answered at all, because this practically is the equivalent. This is practically the equivalent of that. Girl, Duane Youngblood probably would have been better off, bitch, representing himself at this damn point. The judge says that at this motion, baby, to dismiss stage, Jakes does not even have the burden to present admissible evidence. Before discovery and trial, Jakes has no obligation to prove any of his claims by clear and convincing evidence. His burden at this stage is merely to allege sufficient facts that, if accepted as true, state a claim for relief plausible on its face. Moreover, Youngblood's arguments rely on matters extraneous to the pleadings that the court may not consider. Wow. I am experiencing secondhand embarrassment for Youngblood. When I tell you that TD Jakes is whipping ass, bitch, from his last filing to the judge denying, girl, secondhand embarrassment. Secondhand embarrassment, baby. You know what? I too would be asking if there's anybody who want any content down as well, bitch. Larry sitting there screaming out from the bullhorn if there's any hypothetical person out there. Bitch, what Larry need to be doing, bitch, is asking Duane. Bitch, do you need me to take some shit down, girl? Baby, do you need to be asking social media, Larry? Yes, need to be asking Duane Youngblood, bitch. If his ass need you to take some shit directly down, because right now, baby, Jakes don't need y'all to take a motherfucking thing down. Right now, girl, Jakes got it. Right now, baby, Jakes got the course in the chokehold. He on the winning side of this thing, baby. You better go to get the Texan and getting Duane on the line. Getting Youngblood on the motherfucking line and asking him, baby. Do you need me, Youngblood, to take this anything at all now? Would there be of anything of interest on my platform that could better serve to be removed on behalf of yourself or even myself, baby? Baby, the way that I would be leaving Youngblood ass high and dry, considering that Larry claimed that he ain't gonna have nothing to do with this case and he gonna put some distance between him and Duane, then you know what? If that was the case, that would be represented by me making an executive decision as the content creator to remove the goddamn content for my own sake. I wouldn't give a damn how the fuck it looked. To Duane, to the public, to the ops, I wouldn't give a damn. Okay? Baby, y'all giving Jakes too much grace over there by thinking that Jakes is the one scared. Jakes already done proved, girl, that he already waiting first front row at the Ponderosa for y'all, baby. He was waiting for y'all at the motherfucking door, honey. Baby, Jakes ain't the one who shook, bitch. Baby, Jakes gonna sit there and let y'all fall on that epic pride, baby. Thinking that he needs a lifeline, baby. No, ma'am. Baby, the reverse Uno win is the T right now. Y'all can't deal with it, baby. I can't, girl. Between the TD Jakes suit, the goddamn Shannon Sharp suit, girl, look, I'm just a commentator, baby. This is what I get paid to do, bitch. Okay? Y'all said y'all wanted non-biased commentary. There you got it, baby, okay? Not non-biased commentary, girl. I just report the news. Ho, I don't make it up. And I don't get sued for it either. And don't. Given that Youngblood's motion is incompatible with Rule 12b-6 standards, the court cannot reframe Youngblood's motion into a motion to dismiss based on Rule 12b-6. The court role is not to craft arguments for the parties. It is the responsibility of neither the district court nor this court to make the parties' arguments for them. Therefore, we will not engage in a free-wheeling investigation into a legal issue without meaningful briefing on the subject, such as in case law there. The court will dismiss Youngblood's motion because it relies on statutory provisions that are not applicable in this litigation. The court will not reframe Youngblood's argument to fit within the Rule 12b, or Rule 56 framework. Wow, so the court's basically saying, bitch, we're not going to help you. We're not helping you do nothing. Our job ain't to make it clear. Our job isn't to make your half-ass self-defense to work in accordance with the law. That is all on you, buddy. That is all on your wide-neck, ashy-ass attorneys. responsibility, baby. Okay? Our job is not to work for you. Y'all the ones that done pulled up to the courthouse, girl. Okay? So we just gonna act accordingly. If Youngblood wishes to file a motion to dismiss based on Rule 12B of 56, he may do so provided that his filings complies with applicable federal rules of civil procedure. Okay? That baby, do it right. Do it right, honey. Step by step, line by line, precept by precept, because we making zero exception in this litigation, baby. We ain't gonna work no more harder for you than you willing to work for your damn self, okay? So right now, technically, Duane should be cussing Tyrone Blackburn the fuck out. But he probably can't do that since Tyrone Blackburn already ain't making a damn dollar off his ass since he representing his ass more than likely pro bono. What an interesting rock in an even harder goddamn place to be smushed in between, child. Youngblood does not require leave to file a cross-claim against Jakes. The court will deny Youngblood's motion to file a cross-claim against Jermaine Jakes, though. Youngblood requests the courts to leave a file to cross-complaint against Jakes and his son Jermaine Jakes in relation to a message Jermaine Jakes allegedly sent to Youngblood via social media. The court interprets this as a request to file a counterclaim against Jakes and a request to join Jermaine Jakes as a counterclaim defendant. First, the court holds that Youngblood does not require the court's leave to file a counterclaim against Jakes at this stage of litigation. Okay, so if they want to file counterclaim already, they can do so since him and Jakes are already in a litigation. If he wants to go ahead and establish a counterclaim, he can do so. Second, the court holds that whether Youngblood may file a counterclaim against Jermaine Jakes, a non-party, is not fully briefed. The court will address each proposed claim in turn. A counterclaim against Jakes. Okay, we already, he got the right to sue Jakes, so we don't even need that. Let's get to the Jermaine Jakes, okay? He got a right, to counter sue Jakes, okay? Counter-suing Jermaine Jakes, though, as a counterclaim. Youngblood alleges that Jermaine Jakes sent him a message on social media on November 3rd of last year stating, quote, "You might be in dangerous territory. Duane, just be careful." Youngblood seeks to leave to join Jermaine Jakes as a party to this litigation based on this conduct. Federal Rules of Civil Procedure 19 and 20 govern the addition of a person as a party to a counterclaim. Federal Rule 19 determines when joinder of a party is compulsory. Rule 20 applies to permissible joinder of parties. Federal Rule P20, thus the first issue the court must address is whether Jermaine Jakes is a necessary party under the Rule 19 or whether his joinder is permissive. A required party is a person who is subject to service of process and whose joinder will not deprive the court of subject material jurisdiction must be joined as a party if in the person's absence, the court cannot accord complete relief among existing parties, or as discussed above in relation to Jakes, the courts caution Youngblood that one, criminal statutes do not provide civil causes of action, and two, Youngblood may not proceed under the laws of both Pennsylvania and Texas in relation to the same alleged incident. And B, that person claims an interest relating to the subject of the action and is so situated that disposing of the action in the person's absence may, as a practical matter, impair or impede the person's ability to protect the interest, or two, leave an existing party subject to a substantial risk of incurring double, multiple, or otherwise inconsistent obligations because of the interests. Courts treat clauses 1 and 2 as disjunctive, such as in case law here. This if either subsection is satisfied, the absent party is necessary party that should be joined if possible. Under Rule 19A1A, completeness is determined on the basis of those persons who are already parties and not as between a party and the absent person whose joinder is sought, such as in case law there. Jake's claims against Youngblood relate to Youngblood statements on 2 LRL episodes. Youngblood's proposed claim against Jermaine Jakes relates to an alleged social media message which may have had a tangible relationship to Youngblood's statements to LRL. In other words, Youngblood's proposed claims against Jakes arise out of a different transaction or occurrence than the actual subject of Jakes' claims against Youngblood. The court holds that if Jermaine Jakes is not joint to the litigation, the court may still accord complete relief between Jakes and Youngblood. Further, Jermaine Jakes is not a necessary party under Rule 19A1B, as Jermaine Jakes does not claim an interest in the subject matter of the action, his father's claims against Youngblood. Thus, Jermaine Jakes is not a necessary party, and its joinder is governed by Rule 20. Rule 20 states that persons may be joint in one action as defendants if any right to the relief is asserted against them jointly, severally, or in the alternative with respect to or arising out of the same transaction, occurrence, or series of transactions or occurrences, and b, any questions of law or fact common to all defendants will arise in the action. The purpose of Rule 20A is to promote trial convenience and expedite the final determination of disputes, thereby preventing multiple lawsuits, such as in case law there. Joinder of claims, parties, and remedies is strongly encouraged, as in case law there. Accordingly, courts liberally construe the joinder provisions of Rule 20, such as in case law there. Neither Youngblood nor Jakes addressed the Rule 20 standard in relation to the proposed counterclaim against Jermaine Jakes. Given that this issue has not been fully addressed by the parties, the court will deny Youngblood's motion to join Jermaine Jakes as a counterclaim defendant without prejudice until this issue is properly placed before the court and fully briefed by the parties. As discussed above, the court cannot and will not craft arguments for Youngblood, all right? So, the courts are practically saying, girl, y'all ain't even done, it ain't even been enough motion in the ocean yet, girl. Okay, for us to conjoin Jermaine Jakes into this motherfucking litigation for a counterclaim. It does not stand up under the other minor statutes that collectively make up the anti-SLAPP statute of Pennsylvania. But when both parties get to a particular interim in this case, work that out accordingly, then things may be considered. Until then, it's a hell nah. You're going to get a redo. As discussed above, the court cannot and will not craft arguments for the parties. Conclusion. For the foregoing reasons, the court will, 1, deny Youngblood's special motion to dismiss pursuant to Pennsylvania's anti-SLAPP statute, and 2, deny Youngblood's motion to file a counterclaim against Jakes as moot, and 3, deny Youngblood's motion to file a counterclaim against a non-party Jermaine Jakes without prejudice. In order of court will motherfucking follow. Ho. Bitch. My God, today. Then the judge went in again and pretty much put into the docket his ruling at the end of his very intricate breakdown of why he is denying the shit out of Duane Youngblood's anti-SLAPP. Baby, right now, Jermaine Jakes is good. And Duane got some motherfucking problems. Okay, here is the judge's official ruling. All right, court of order. And now this on the 25th day of April, 2025, it is hereby ordered that Youngblood's special motion to dismiss pursuant to Pennsylvania's anti-SLAPP statute is in fact denied. It is further ordered that Youngblood's request to file a counterclaim against Jakes is denied as mute, and Youngblood's file to file a counterclaim against Jermaine Jakes, a non-party, is denied, but without prejudice. Wow, 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 wow. Major legal win, girl, for the Jakes of it all. Do you guys have any questions for me? Okay, this is your Q&A session, child. Okay, hey, the Lee Williams Show. The Lee Williams Show says, now I'm all for Larry Reid, but why would he get entangled with the Duane Youngblood? Shaking my head. I mean, if you believe what comes out of Larry's mouth, his claim is that he doesn't have any personal issues with Jakes. He's only allowing his friend, sex offender Duane Youngblood, to speak his truth, and claims that the TD Jakes segment of the interview was only 15 minutes of a larger conversation that was about Duane's life story and how he has been allegedly religiously SEX trafficked through the church since Duane's been a young kid, and that TD Jakes specifically carved out the part about himself, to make a fuss of, which, as far as I'm concerned, is Jake's goddamn right. Like I told Larry to his damn face last year. I said, Jake's has no responsibility, or it should not matter to him whether he was spoken about in a 2-hour interview for 15 minutes or 15 damn hours. Whatever was spoken about, if it was slanderous, untrue, heinous, and injurious, baby, all it takes is 15 goddamn minutes. His job is not to sit there and say, you know what? Let me not find no issue with this man accusing me of religiously grooming him and actually trying to groom him just because he's spending the bulk of the interview dragging and slandering every other goddamn pastor. Do you really think that's what the fuck Jakes was supposed to do? Was Larry going to not sue Daryl more just because Daryl was also talking about everybody else? No. Daryl boy got sued to the goddamn ground and gagged to the motherfucking ground. So it don't make no logical sense for Jakes to consider any other optics aside from the ones that directly relate to his ass. And apparently 15 minutes, baby, was all too motherfucking long to have one's dick sucker on his name, baby. What's going on, Danny? Lee says I'm shook of the girl. So the question of why, I mean, if you take what Larry said, he was just having a conversation with his sex offender friend, and it was just supposed to be about the totality of Duane's experience. Okay, so he's saying Jakes, for him, was not the focal point. It was Duane's story as a whole, which I'm going to continue to call cap, like I've been calling cap, because I don't know why Duane even has a platform, considering that he just got out of fucking prison, last year? For violating probation by making contact with another underage boy. So who really gives a fuck to hear from Duane? Duane is not the poster child for a recovered, restored PDF file. I'm sure there are people who fit that bill. Offenders who have been restored through psychotherapy, deep counseling, and have participated in every other restorative system known to man, and have been living a life that is and has been aligned with their healing for years on end. Could Larry not have given Duane at least 10 years on the right path before he even tried to make Duane relevant to the culture when the nigga was just getting out of motherfucking prison for violating probation as a sex offender by making motherfucking contact with another underage boys. I mean, but as I've told Larry to his motherfucking face, baby, the math ain't mathing. The math ain't mathing. And there ain't nothing about it making no motherfucking sense. And if it don't make sense, that it don't make truth. So I don't know what the fuck this really is about, because the general consensus of all this is that this was another attempt to injure TD Jakes. That's what the general consensus is. That's what, most of the viewing public believes, is that Larry has a personal dildo up his ass for TD Jakes, and that has come through by whether it was using Bishop Carlton's strife with Jakes as a means to get at Jakes, whether it was using Manasseh's situation with Jakes to get at Jakes. Now it's Youngblood, so the public, is seeing a pathology and a pattern. So, I couldn't even tell you the Lee Williams, baby. I don't know, but I don't know. I just couldn't tell you, child. Thank you, Palace. Hey, baby. Hey, baby. Y'all want a non-bias, baby. This is what non-bias. Baby, 2025 has been a non-bias CTV, baby. Okay? I'm just giving my quote-unquote non-biased commentary. All right, Truth Teller says, thank you so much, Medusa. I love y'all, boo. Thank y'all so much. I do this for y'all, baby. Y'all been throwing coin on the cane, baby. Y'all been thumbing up, baby. Y'all been showing out on me, so I'm going to show you out on y'all with the commentary. Truth Teller says, do you think Blackburn may abandon your blood? He probably won't be able to. I mean, Tyrone Blackburn could submit a memorandum requesting dismissal for whatever reason from the case, but considering that the courts already had given Youngblood space and opportunity to find himself legal representation, because, he was saying he was going to need a continuance. He was only working part-time. He broke as hell. And, he just need to find legal representation. The courts probably won't let Tyrone Blackburn abandon Duane, since Duane came into this litigation struggling. Which, to my whole thing is, why open your motherfucking mouth if you wasn't ready for the fight to begin with? Who puts their mouth on a multi-million-dollar ass person and then literally, like, in the worst way possible? Let's say Duane was telling the truth. You do know that even when you're telling the truth, right, you can still be sued. Okay? So even if, let's say this was true, me personally, as strategic as I am, bitch, I still would not have told the truth unless I had the coin to see Jake's ass in court, because clearly, why would Jake's allow me to sit on a platform where the interview has the potential to go viral and then just let that slide? Of course he's not going to. Of course he's not going to. Because if the shit fucks around and go viral, bitch, I am going to absolutely have to see about this nigga. So even if I was telling the truth about Jake's, bitch, I would not have told the truth publicly as a broke motherfucker. But considering that Duane probably is a dumb broke motherfucker, he let Tyrone Blackburn talk him into the idea that, oh, Jake, trust me, Jake's is settled. Jake's is settled. He's a part of one of the most conservative communities in the world, which is the Christian community. As a black pastor as that, he's not going to want none of the publicity behind this shit. Of course he'll settle. with us out of court. Girl, undoubtedly under fucking estimated. Okay? Underestimated. Hey, Palace. Hey, Joshua. Baby. Youngblood never ever had a chance, baby. Not under these circumstances, honey. Not under these motherfucking circumstances, okay? What's going on, Esha from over there? Baby, oh, I got so many Texans, honey. I'm going to have to come visit Texas. I'm going to have to come visit Texas. I got an ex who just moved out to Texas like 2 years ago, child. Shout out to Texas. Medusa says, I've been off and over TD Jakes. He's never did anything to me personally. Danny says Larry was trying to hurt TD Jakes' pot area. Baby, let me tell you something. Baby, when they get to this discovery part of this motherfucking lawsuit and Jakes circles the block on discovery and wants to pull Larry ass into discovery, girl, for Larry's sake, baby, I hope I ain't talking about the front end because I'm sure Larry ass has enough sense to get rid of anything on the front end of his devices. But he better hope that the back end look equivalent to the front end. Because if not, because let me tell you something, baby. Jakes already established in his lawsuit that he doesn't trust Larry. He believes Larry is a liar, a manipulator, a deceiver, is a weasel and a snake. What that makes me believe, then, is that Jakes is probably prepared to, or at least understand that Larry more than likely has scorched and purged his devices, his emails, if there's even been any foul play on Larry's part. With Jakes coming in with the attitude against Larry that he already has, I'm sure, baby, the goal is going to be to subpoena Google. It's to subpoena Larry's phone company and get the real receipts and the real transcriptions from these companies themselves. Because he's already come in not trusting Larry. So he knows damn well there's not going to be anything on the front end to get. Everything on the front end is going to look clean. So if there's been any foul play on Larry's part, and he's been a part of some secret conspiratorial coup against Jakes, and he's been feeding information, and they've been strategically setting this shit up and lining this shit up, all that shit is going to be seen on the back end, straight from the company's receipts. And Larry gonna have some civil motherfucking issues if there's been foul play. If whatever he's contributed to this situation with Duane Youngblood is and has merit under the law civilly, he gonna have some motherfucking problems. And the court's already said that they were not going to greenlight a early discovery on behalf of Jakes regarding Larry, but that when that time comes, Jakes is more than welcome to represent, his request. Not Yvette says Larry going back to the baby, if I was his ass, I'd stay right over there until the whole goddamn case clear, girl. I'd give me a whole residence over there and everything. But I pull a damn Star Marie, baby. Okay, we'll be gone until this case concludes, girl. On period. Let me see here. Medusa says, I don't even say swallowed up anymore. My God, okay? Jakes done ruined it. Truth Teller says they were betting on Jakes giving them $6 million because he's a pastor and this is bad press. They didn't think he would fight back. Nope, baby. And they did everything to deter Jakes from speaking. They threatened him with other accusers. They threatened that there was going to be all these demons and devils and all these exes and everything else coming out of the woodwork, baby. That they definitely put up a strong intimidation tactic against Jakes. Baby, they underestimated Jakes, girl. That's one of the rules of the art of war, is never underestimate your motherfucking opponent. Never. So this is going to be very interesting, y'all. Nepin thus says, Lord, I don't have this type of energy talking all by myself. Woo child, yes, honey. We all got them exes in Texas. Shout out to my baby mother, Sonia, for the audacity piece of child support for you do the work, but don't forget to rest. I won't, baby mother. Thank you so much, honey. I'm going to rest. Okay, I promise y'all, I ain't coming back today. I'll see y'all tomorrow, okay? Or maybe Sunday, okay? But there's a lot going on, child. There's so much going on, child. Y'all will probably see me tomorrow, but this is going to be the last live for the night. Let me see here. Not Danny said with his boyfriends. My God, today, Danny. My God, today, child. Okay, let me go back up and read some of the comments that you guys put, because I didn't have a chance to see what the hell y'all was saying as I was reading, child. Okay, let me see. TD Jakes TD Jakes got his boots to the ground. That part, girl. This is a mess, honey. This is a whole mess, girl. Okay, Youngblood and Blackburn are getting swallowed up. Daddy says, how in the whole hell they even thought that they were going to win? Because, you know, like I said earlier, I don't think they even were planning to get this far in. Tyrone Blackburn thought they was going to really get that $6 million payout. They thought that was going to be the end of it, baby. That's why, if you look at the optics of it all, why Youngblood was so unprepared. That's why he had to ask the court for continuances and shit, because he didn't even have representation. They were really banking on that out-of-court mediation. And hell, additionally, Duane was going to try to get that $6 million by his damn self. Until he saw what was at hand and realized he didn't know what the fuck he was doing or how the fuck to go about this. And had to take Tyrone Blackburn up. Child. And now that's looking like an epic non-asset, because woo child, Duane getting swallowed up, girl, and he might be taking Larry into the eye of the storm with his ass, baby, since this suit done put Larry on Jake's bad side as well, baby. It is a mess. Youngblood was lying the whole time. Lying, and more damn lying, child. Youngblood is leaving with everything he came with, and that's absolutely nothing. I knew Youngblood was a liar. I'm sick of these grifters, girl. Okay, Jakes must have some sons of David. Quality. I don't know why Duane with Tyrone, girl. Tyrone got half a star. Half a star. A star. Tyrone is not. Okay? Sweet Love says, Jake got him this time, but Larry will be okay. Baby, Larry ain't out of the woodworks, unfortunately, child. He better be over there lighting them 7-day candles and shit, because, baby, this thing is far from over, baby. They just warming up. Hell, even the court's done established, girl. As far as the courts are considered, you know, this is still the early stages of litigations, child. I'm like, damn, you know, how long is this gonna play out? You know, when is the trial date gonna be set, girl? They still slapping paperwork every which way. So now that the courts done denied Youngblood the anti-SLAPP, the next thing coming on the docket probably is going to be them giving Youngblood maybe a date to respond to all of the existing issues in his anti-SLAPP motion. Maybe give him a time to, you know, really define his anti-SLAPP so that he can submit it and they can deny it again. Okay, so we're going to be seeing probably some dates and some deadlines and some scheduling coming down the hall, honey. Oh, yes, God. Okay, let me see here. Let me see here. Danny says he's a master manipulator. Yes, I said it. Palace says more than willing. That's what we say in Mississippi. Sweet Love says Larry nor Youngblood are innocent. Larry used him. I don't care. Larry has an agenda. Notice that he is using his minions, which is all them weird ass, ugly ass folk. That's it over the other side of YouTube, girl. My God, today we can't do better. No, we can't. Palace says I'm on the cusp of Aquarius. Believe me, we plan things out. You know, and here's the thing: there's nobody that's going to be able to help Larry or Duane ass out. You know, the court of public opinion is completely irrelevant, baby. And as I said in earlier live streams, girl, you know, look, all I can say is, baby, I tried to help Larry keep his public image intact, girl, and everything. Larry just doesn't have the same. People don't feel the same way about him anymore. The way that Larry has moved has really moved. Larry already was kind of a controversial figure anyway. That got even more sliced in half as Larry kind of moved in ways that was zigzag, and then there's been all these 50 million 11 exposés on Larry by Levantre and Lester and Vincent, and the list goes on and on. All this shit has contributed to a lot of people just don't take Larry seriously anymore. They just don't really largely see him as a credible person. People really feel like he's did more telling other people's truths than he ever did standing in his own when it was all said and done. And, you know, the fact that Larry also has no type of, either he has no social awareness or he just chooses to do whatever he does for whatever reason he does it. But to then double down and have friends who also are extortionists and are slanderers and who have also been sued for spreading misinformation, aka the Crypt Keeper. All this stuff just adds a destructive stankness to Larry's brand. So at this point, I can't even say nothing to the public about Larry. I can't say nothing. I mean, you know, Larry allows shit to look how it looks around him. So, you know, I just have to let him lay in that bed because, you know, I mean, you know, Joshua says, I would love to hear what Larry has to say. I'm sure he gonna enter the group chat, girl. Even though he always claims he done. He ain't gonna say that. But Larry can't help but run that damn out and say something, child. So I'm sure he'll be saying something. The internet is under siege due to the storm. Okay, y'all got a storm. Okay, but God bless protection, child. Okay, Medusa says, you did try CTV. You went to bat for him. I remember all the discussions and panels. I'm glad you're letting the chips fall where they may. Baby, I got to protect my peace because you know what? Not only do I got a peace to protect, but, you know, these niggas wouldn't even do the same for me, baby, if the shoe was on the reverse end, okay? CTV done had to be out here windmilling for my damn self, fighting for my damn life, baby, when I done came under fire for being cyber stalked and every damn thing else, child. So, you know, I'm sticking to the business that pays me and maintaining my motherfucking peace. And, you know, ultimately, I'm just not really, I'm not interested in, I'm just not putting nobody before myself. And ultimately, too, I'm also, I made a decision that I was going to let people live the life they create. and not impose myself. Which means that what a person may be choosing to do, as destructive as it is, as stupid and ignorant as it is, as whatever it is, if I actually give myself permission to respect that shit. I give myself permission, baby. Yeah, baby, to just, lay down if that's how you want to make your bed, baby. Okay? I'm not about to fight and tug and tussle and wrestle with you about you. Because, baby, if you cool on it, why the fuck can't I be cool on it? So, baby, I'm cool on it. I'm cool on it, honey. You can be my best friend. You can be you, do your best. Hey, Andrew, I'm in the bushes, worn out from life lately, but I had to come out and support your courage in this moment. Thank you so much, Andrew. Thank you, baby. And God bless you, boo. I got the message. So, I'm sending light and love to you, boo. Please keep your head up. And know that all storms don't last forever, baby. Everything has an expiration date, including the uncomfortable times. So we send the light and love to you, boo. Yvette says Larry should have paid old boy $25 for a Jesus, baby, pay somebody something, child. I don't understand. You do the best you can, but things will be what it can be. I love you too, pal. Facts. CTV, protect your peace. On period. Do LRL listen to you, CTV? I'm worried about him and his new crew. No. Larry does not listen to me. Larry is what's a political way of putting it? Larry is an Aquarius. Larry is used to, thinking he's the smartest crayon in the book. So Larry does not do well with he might listen, but taking heed is the other. Larry is somebody who's very adamant and persistent about going about, of doing things however he's going to do those things, child. So, you just get out of the way. Okay? And let him stand in traffic, baby, if that's what he thinks is best, girl. CTV, I'm kind of high a little bit. I'm screaming. When they show you who they are, believe them, child. But it's heartbreaking because I know how much you love Larry. Well, don't be heartbreaking, baby. Okay, because nothing that happens to Larry is gonna happen to me. So be more heartbroken for Larry. Okay, because baby, we all want the best, for everybody and stuff, child. But believe me, baby, hey, baby. Whatever Larry's behavior is, girl, it'll cost him. It don't cost me nothing. His bad decisions or his questionable decisions or whatever the hell you want to call it, baby. It don't impact me in no kind of way, baby. Baby, be more heartbroken for Larry, child. Don't be heartbroken for me, baby. We blessed and highly favored over here, girl. I just love this platform with my fellow water sign, period. Joshua says, I thought you was in tight with Larry. I would have thought he'd heed to your insight, girl. Ain't Larry done told y'all he don't listen to no damn Bible? He don't listen to Shamako. He don't listen to his ex-wife, baby. He don't listen to Kendall. Ain't y'all see Kendall always trying to pull Larry ass off the curb, baby? Larry is not he once again, he may listen, but taking heed, girl, is the problem. The listening, not so much the issue. It's the taking heed to wise counsel, baby. That's the problem. We tried to warn Larry about a lot of things. We tried to warn Larry about Vincent. I warned Larry about Vincent. I warned Larry about Lester. I warned Larry about Tasha. I mean, there's been nothing that I haven't warned Larry about, baby. It's all come to fruition, girl, okay? As somebody said, I think somebody said last year in one of the times he was over here, And somebody said, child, CTV is really the goddamn mentor. Larry is the goddamn mentee. And that is true tea, bitch. That is true motherfucking tea by every measure of true being tea. I'm going to pray for God's grace for Larry. Yes, baby. Just keep him in your prayers, child. Keep TD Jakes in them too, child. Hey, beautiful loved one, Styles. Hey, Bo. Hi, my love. Protect your PCTV. Absolutely, baby. I'm committed. Child, I felt attacked when you said he was because I was dealing with a crazy jacket. Baby, I had a twin flame that is an Aquarius girl. So I had vowed years ago. This was before I was even really seriously content creator. I said, baby, I can't fuck with them Aquarius, bitch. Baby, I can't. I said, baby, a Aquarius got to have the Holy Spirit for me to fuck with them. And all of my experiences with Aquariuses have been very, very bizarre, girl. And right now, I am just taking heed that, baby, I don't need, a Aquarius personality type amidst me, girl. Because it just, yeah, baby. It ain't even worth all the hoopla, child. It's completely overhyped. Completely overhyped, child. I learned from UCTV on period. He didn't listen to his parents. I'm in the cusp on the period, girl. So, I don't know what's gonna happen, girl, but right now TD Jakes is winning the race, y'all. So what will become of Duane? I don't know, girl. But this is my non-biased commentary. And y'all have a blessed night, child. I'm gonna go on relax, find me something to watch, child. Y'all thumbs up, run it up, run it up, run it up, run it up. And if you guys enjoyed yourself, you can always show love on the old Dancing Piece of Cash app, Consciouztv, and or paypal.me/Consciouztv. Also email me or the tea, any updates, anything having to do with anything, email it to me at consciouztv@gmail.com, and or follow me on Instagram and DM me at Consciouztv on Instagram, and sign up to the Patreon, which I will be in tomorrow morning. To get into these crazy ass updates, girl. I gotta get into these crazy updates regarding the Carmelo Anthony, Austin McCaff situation, child. So y'all be locked in. For those of you who have not signed up yet, I always post when I'm going live in Patreon so that you guys know that I'm in Patreon and have opportunity to sign up. So I'll post to the community wall. Check that out. Check out, girl, the Shannon Sharp second accuser situation, girl. That shit is not nuts. Oh, it's nuts, baby. It's nuts. It's nuts. It's nuts. And all the things, child. So I love you guys, and I will see you guys tomorrow morning. Bye.